Hello, I'm George Whipple. The month of March brought important regulatory changes for employers on the federal and state levels, including some long-anticipated rules and some new trends. Let's take a look. On March 18th, New Jersey enacted a law that limits the use of non-disclosure provisions to maintain confidentiality regarding workplace harassment, discrimination, and retaliation claims.
The new law specifically makes any non-disclosure provision in an employment contract or settlement agreement that, quote, has the purpose or effect of concealing the details relating to a claim of discrimination, retaliation, or harassment unenforceable against the employee. In the wake of the Me Too movement, non-disclosure agreements have been the focus of many legislatures. New York, California, and Washington are among the states that have enacted bans or restrictions on such contract provisions, and a number of states are currently considering such measures. Most of these laws, however, are narrower in scope than New Jersey in that they're limited to banning disclosure of sexual harassment claims, whereas New Jersey extends to any form of harassment, discrimination, or retaliation.
The U.S. Department of Labor issued its long-awaited proposed changes to overtime salary thresholds, which replace an Obama administration rule that was blocked by a federal judge in 2017.
The department has announced that it wants to update the regulation governing the exemption for executive, administrative, and professional employees, and it wants to do that by increasing the minimum salary threshold to $679 per week, which is an increase of about 50% over the existing level. The department contemplates in the rulemaking that the final rule become effective in January of 2020. That's probably a bit optimistic. If we look at the normal timetables for rulemakings of this sort, it would be more likely to see the final rule issued in late 2019 or early 2020, becoming effective in early to mid-2020.
Another federal judge has hit the restart button on Obama-era EEO-1 pay data collection requirements. The Office of Management and Budget stayed the requirements in 2017 before they went into effect. It's unclear what the impact of the judge's decision to lift the stay will have on the 2018 EEO-1 reports, which are due May 31st.
The judge found that the OMB's review and stay of the new EEO-1 report was an arbitrary and capricious administrative action because it lacked a reasoned explanation and was therefore illegal. Right now, it's still unknown whether the OMB will seek to appeal this decision. If it does do so, it may also seek a stay of the court's order pending the appeal. This decision further illustrates that pay equity issues are not going away. Employers should use it as a wake-up call in order to examine pay equity issues within their own organization and should consider conducting a pay equity audit.
The EEOC has said that for 2018, it will require Component 1 data detailing the demographics of an employer's workforce, but not the new Component 2 wage and hour data. However, there is legal pushback on this, so those requirements could still change. A new regulatory trend is beginning to emerge in the hospitality sector. New Jersey and Illinois have both proposed legislation that requires restaurants specifically to institute sexual harassment training policies. Unlike in California and New York, there is no legislation in either state requiring this sort of training for all private sector employers. It's too soon to tell yet whether sexual harassment regulations are beginning to get more industry specific, or if we're simply seeing a reaction to recent scandals in high-profile restaurants. We'll be monitoring developments in this area. And finally this month, Aney Chandy is here with some tips on how employers can address gender identity inclusion in the workplace. Aney is Allergan's Executive Director, Senior Counsel for Labor and Employment.
Evaluate and update your policies. A good first step is to update your anti-harassment or anti-discrimination policy by including gender identity or expression among the protected categories, even where it may not be required by law. Engage with your employees. If you have an employee who is transitioning, talk to them. Work with them to develop a workplace plan that addresses their desires regarding communication, changes to their HRIS profile, preferred names or pronouns, employee benefits, and any other issues that may arise. If you have an employee who is uncomfortable with a transitioning employee, talk to them. educate and train your employees regarding these issues and your organization's philosophy regarding compliance with the law and inclusion.
Thank you to Annie for that sage advice. And thank you all for joining us. We'll check in again soon.